everybody. Welcome back to another episode of Injustice for All with Judge Joe Brown. And today is going to be a really good episode because we're going to be talking about the Voting Rights Act. Yesterday, the Supreme Court heard arguments regarding the Voting Rights Act. The Supreme Court on Wednesday appeared ready to strike down a 2024 congressional map that a group of voters has challenged as the product of unconstitutional racial gerrymandering that is, according to them, it sorts voters based on race in violation of the 14th Amendment's Equal Protection Clause. During nearly 2.5 hours of oral arguments, the court's conservative justices signaled that they are likely to undermine a key provision of the Voting Rights Act, even if they may not ultimately strike it down altogether. So Wednesday's oral argument was the latest chapter in a dispute that dates back to 2022 when Louisiana adopted a new congressional map in the wake of 2020 census. Roughly 1/3 of the state's population is Black, but the 2022 map had only one majority Black district out of 6 districts allotted to the state. That prompted a group of Black voters to go to the federal courts. They argue that the 2022 map violated Section 2 of the Federal Voting Rights Act, which bars discrimination in voting practices. U.S. District Judge Shelley Dick agreed that the 2022 map likely violated Section 2. She prohibited the state from using the map in future elections and ordered the state to draw a new map with 2 majority Black districts. The U.S. Court of Appeals for the Fifth Circuit upheld that ruling. It gave the state until January 15, 2024 to enact a new map or face the prospect of the lower court would adopt a plan for the 2024 elections.
What's really going on about this is American law, constitutional law, as it's been interpreted and applied over the last 230 some years, has allowed remedies to correct prior wrongs. Okay. The Civil Rights Act of almost 60 years ago, Voting Rights Act, was such a correction, but the wrong, to all intents and purposes, has been corrected, as exemplified by the fact that we have had somebody that at least nominally is part of the protected group holding the highest office that you can hold in America, that is President of the United States. That would be Obama. Senator, member of the U.S. House, commanding general of the U.S. Armed Forces, that would be Colin Powell, as chairman of the Joint Chiefs of Staff. Let's see, you've had a chief of staff for each of the military agencies being part of the protected group. You've had a secretary of state. You've had attorney generals. You've had the whole panoply. So there is no office that the protected class is not held, and it is in fact in more local politics. They control the political outcomes in just about every one of the largest cities in the United States. That would imply that the purposes of the provisions of the act have been accomplished. And when the reason for a law ceases to exist, so must application of the law, and that's the general theme behind the whole thing. The equality of circumstance in American law would dictate that if this situation was allowed to stand as it is now, then there would have to be precincts or districts where they're predominantly Jewish, predominantly Asian, perhaps breaking that down to Filipino, Chinese, Japanese, Taiwanese, Korean, you name it. There'd have to be a situation where you could say they have to break it down so they're Protestant districts, Catholic districts, Jewish, well, we already went there, Jewish districts, Buddhist districts, Hindu districts, and that kind of thing. We've got a new heavy contingent from India, so you would have to have Hindu districts and such like, and that gets a little preposterous because that defeats the purpose. And there's an underlying assumption to this whole thing that is not mentioned these days because it's long been water under the bridge, and that is that the interest of white people and black people are so diametrically opposed that there's no realistic opportunity for a black candidate to win in a district unless it's predominantly black, and there's no commonality of interest between black voters and white voters. So what happens? We have Letitia James in New York, Vivica, well, not Vivica, I know her, Fox in Illinois. You have the mayor of New York. You've got Fannie Willis in Atlanta. You've got LaButte in Atlanta. You've got black sheriffs all around the country, including here in Memphis. So in these former bastions of what was the carryover from a very racist situation 60 years ago, the purpose for the law no longer exists, and it's part of this thing that you see from the left about why would anybody black vote Republican? Well, there are a number of reasons why so many blacks have decided to vote Republican. But the general operative theory is that it would be impossible for the interest of the black residents or constituents to be represented by anybody white, or the interest of somebody white being represented by anybody black. So there is that operative assumption in the whole scheme, and it's somewhat obsolete. So when you come up with this thing nowadays, it runs into the same problem that affirmative action ran into when it was race-based. We've had this discussion before. If the basis for something is neutral, it's permissible even if it has a primarily racial effect to under certain circumstances. But you cannot say black people need to have a particular set aside. Therefore, there should be a quota, either so many black employees out of so many in total, or so many black students admitted out of such and such total, or so many black districts out of so many in total. See, the American system doesn't really embrace quotas except as a remedial matter. And what we have right now with the way the Voting Rights Act is set up and the way the districts are now being set up essentially establishes a district styled quota. And that's not permissible under American law, at least not under the current circumstances. So it is what it is. It's like, take my show. When I first got it, they wanted to make it a black show. And I said, no, I'm not going to have it a black show. It's going to be an American show with a black man running it. All right. And it wound up being number 1 or 2. And see, Hollywood's predicate was that no show operated by anybody black could make it in the mainstream, but I said, yes, it can. So it wound up number 1 or number 2 with the most viewers over a 10-day period in the country. So it worked. And that had nothing to do with the fact that you had to limit it to something black. So you get these things where right now the popular conception is looking at Jasmine Crockett's. They're looking at Cory Booker's. They're looking at Maxine Waters, and they're saying this is crank stuff. They're looking at AOC, and they're saying this is, you know, what the districts are entitled to select, but this doesn't have anything to do with mainstream black, white, brown, red, yellow in Texas, New York, Los Angeles, or anywhere else. This is just something that's over there on the far left that is operating under the cover of getting something black. It's like voting as a state for Washington, D.C. doesn't work. Why? Washington, D.C. has maybe 300,000 people as a city, a municipality, but 300,000 people would be a very, 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 very small state, and there's no justification for having 2 U.S. senators represent that few a number of people, nor to have 2 U.S. congressmen representing those few people. And the purpose is to give the far left enhanced influence in Congress. So that's kind of
But
what is
maybe
being
isn't
complained about in this case. Is it's just a dodge to get undue
so
influence for a certain far left political perspective that has nothing to do with black, white, brown, red, yellow, and is being effectuated by the artifice of having a quota for congressional districts.
but the far right, the Republicans can be doing the same thing as well.
Well, but the point is, I voted for Trump. A whole lot of black folk I know voted for Trump. So what is the alternative being used? Is there a viable candidate, which I suggest right now can be elected in a varied district? It doesn't make any difference what the person is. But you see, the objective is to get a black female elected, or secondarily, maybe the right kind of black male elected who would push a certain agenda. And the problem is that that's not necessarily the case, because there are black Republican candidates and they thrive in Republican dominated districts, which come up when you just set the districting based on other criteria besides race.
I want to play this clip, and I want to play a couple of clips from the hearing. And right here is a clip from the attorney. She is attorney for the NAACP legal defense team, Janae Nelson. I hope I'm pronouncing her first name right, Janae or Janae. And it's 34 seconds. And what she said is pretty interesting.
That's right. And in the state of Louisiana, that analysis was conducted in the Nairn case. And it was clear that regardless of party, white Democrats were not voting for black candidates, whether they were Democrats or not. And we know that there is such a significant chasm between how black and white voters vote in Louisiana that there's no question that even if there is some correlation between race and party, that race is the driving factor.
Can you comment on the Solicitor General's suggestion at page 20?
All right. So her comments, like she said, white Democrats, white registered people who are white, registered Democrats, they don't vote for black candidates. So it's not even about Republican or Democrat. It is, when we talk about white people are most likely going to vote for another white person as opposed to if a black person is running. And black people, vote identity politics the same. So did you hear her quote
I heard
on that?
all of what she said. I heard all of what she said. The problem is that, are you going to get an AOC or a Jasmine Crockett? Is that what you're talking about? Like, I can't see how any sane voter would vote for somebody like that, whatever their ethnicity or the demographics. But is that what we're really talking about? You can't get that kind of person involved in the process and successfully elected? And is what the issue really boiling down to is not that certain demographics won't vote for other demographics, just won't vote for the political perspectives that are associated with a certain demographic. If that makes sense. In other words,
All right.
would the district vote if there was a Clarence Thomas running for office? Would you get white votes for somebody like that, conservative? Yes, probably you would. But if you reference black as being exclusive domain of a Jasmine Crockett, no, you're not.
And we are talking about the state of Louisiana. And so it's still the South. And, if we are going to assume, maybe the assumption is there's still a good portion of white racist people in the South, or someone who may be white and a bigot that don't want to vote for someone because they're black.
Well, that's true to an extent, but the heaviest concentration of black elected officials are in the old Confederacy, the 11 states that seceded from the Union in 1861, and that includes Louisiana. So you have, interestingly enough, the juxtaposed contention that these are the most racist areas in the country, but they also coincidentally happen to be the areas with the highest percentage of black representation.
Right. So I want to play this clip of Ketanji Brown.
I'm not taking one particular position over another. I'm just trying to explain the alternative position, which is reasonable. So let's see what Ketanji Head Scratch Brown says.
But I would ask you to just expound a little bit on why you think then that Allen versus Milligan is relevant, or the fact that we held or what we held in that case is relevant to what we're doing here today.
Allen versus Milligan is a nearly identical case. There was a similar challenge that where we won on a preliminary injunction that there was a Section 2 violation because the state of Alabama in that case cracked and packed the black community, cracked the black belt. And ultimately, this court found that that was a clear violation of Section 2. Similarly, what we have in Louisiana is a circumstance where Louisiana was constructing a map and had a single district that could elect a preferred black candidate and had an opportunity to draw a second district based on the size and geography of its black population, and chose not to do so in the face of 7 illustrative maps that made clear that they were not dilutive.
And what we in part were considering in the context of Milligan was whether or not to change the Section 2 criteria, the Jingles criteria. Is that your understanding?
That's right. The state of Alabama
and we chose not to.
The court was very clear about that.
And so the parties, I took your initial starting with Milligan to be a suggestion that we not revisit the determination that we made just 2 years ago that the Jingles test not be revised.
That is absolutely correct. And in fact, appellees on page 11 of their supplemental brief state that they understand that this court answered that question clearly, that the results is a constitutional test, that race can be used to remedy violations, and it therefore isn't making that particular argument. In fact, even the SG acknowledged that race can be used in a remedial form when necessary. So those questions have been asked and answered by this court in Allen versus Milligan, and some parties here recognize that those are closed questions.
That's like I said. Well, that's like it. race can be considered for remedial purposes. Once the problem is remedied, then there's no longer a need to consider race. So in the 21st century, 2025, has the race problem been remedied such that there is a realistic chance of a black candidate being elected in a predominantly white district? Well, look at Tish James in New York. Look, Fox is state's attorney in Illinois, you see. Look at LaButte as sheriff down in Atlanta. Look at District Attorney Fannie Willis. Look at Mayor Bass in Los Angeles. Look at Mayor Johnson in Chicago. And are you saying that black people cannot get elected in a predominantly white district? Obviously they do. So you have illustrated that the problem is to a great extent cured, and you still get on to something that they need to pay attention to. What about the Asians? What about the Native Americans? What about the Hindus? What about Jews? What about Muslims? What about Buddhists? What are you going to do when you start saying these identifiable ethnic groups, these demographics, are not likely to get somebody elected where they are, and they're underrepresented in the halls of various and sundry legislative bodies, particularly the U.S. Congress? Now, look at the furor that's being generated over the far leftist person running for mayor in New York with his ethnic specifications. So he doesn't have an unrealistic chance. He seems to be getting a lot of play from the media anyway, at least in terms of the views that he's expressing, which do appear to have some traction. What about these people that you're dealing with right here? Do they exist or do they not exist? See, what are you going to do about this guy in New York? Is it his philosophy, his agenda that renders him a realistic candidate, or is it his ethnicity? See, the argument that is in front of the court right now is predicated on the entire appeal has to do with the ethnicity rather than the agenda. And that's not the way American politics is supposed to work, because if you allow that, then you allow old-time racism to come into play. In other words, you've got favoritism to white Anglo-Saxon Protestant voters.
You want to pick her up?
Oh,
The dog that's making all that goddamn noise.
it's on the far side of the kitchen. So anyway.
All right, I want to play this clip of Clarence Thomas.
Why did the state of Louisiana switch sides since our last argument?
Your Honor, we told the court at pages 1 and 2 of our original opening brief in this case that our predicament in this case presents as good a reason as any for the court to reevaluate its voting precedents. We told the court at page 18 of our original reply brief that we thought this would be a different case if the court thought it was worth revisiting the longstanding assumption that compliance with Section 2 is a compelling interest. Your Honor, we thought all along, and in my colloquy with Justice Kavanaugh back in March, we discussed our longstanding position in our state legislative map litigation, where we have taken the position that Section 2, insofar as it requires race-based redistricting, is unconstitutional. This court's re-argument QP squarely tees up that question, and so our duty of candor requires us to give the court our honest answer to that question.
Okay. Can you hear me?
Yeah, can you hear me? Did you hear that?
I heard that. It's the same thing that I just raised in terms of the observations I stated. It's like remedial, yes. As a general policy, no. You cannot have the introduction of a protected category as a favored category. There is a difference. In other words, I can't discriminate against you because you're a woman, but I can't act in favor of you because you are a woman. You get the difference?
Yes. Say that again, please.
I can't get against you because you are a woman, but I cannot act giving you an advantage because you are a woman.
Okay. That makes sense.
That's what they're doing. They're saying black people advantage in this districting versus what happened 60 years ago. They set the Civil Rights Act dealing with voting up so that you could not have discrimination based on race. In other words, there was a perception 60 years ago that blacks and whites were so diametrically opposed in interest that nothing that favored black folk, nothing that accommodated them, nothing that made it neutral would come out of any legislative body that did not have special attention to a process of selecting an adequate number of black representatives to protect the blacks from discrimination by the whites. Now, that's not the case now. There are other interests involved here. The Republican Party is actively trying to solicit black folk. The Democratic Party presumes they have black folk, and they are soliciting the support of black folk to deal with rainbow folk.
All right. So I want to play this next clip of Kantanji.
So in essence, are you saying in response to Justice Barrett that it's a compelling interest nonetheless because the state has an obligation under our Constitution and under Section 2 to provide an equally open electoral process?
That's correct.
I mean, I guess what I'm trying to really wrap my mind around is the different stages of this case and like the different questions at issue, because it's complicated. But I think the beginning of the whole thing is the requirement of equal protection in the Constitution and Congress's determination under Section 2 to make sure that that is being provided to minority groups in the electoral process by having a statute that requires states to provide equally open electoral processes. I mean, that's what we said in Milligan. We were very clear that individuals lack an equal opportunity to participate when a state's electoral structure operates in a manner that minimizes or cancels out their voting strength. I mean, everybody, I don't think there's a disagreement that we have this initial goal, which is providing equal opportunity. And so then the Robinson Court is asked under Section 2, is this a situation in which that's not happening? And they go to trial and they bring in a lot of evidence and they do the thing, and the Robinson Court says, yes, this is that situation. Fine. I guess I don't understand why the Robinson Court's decision is before us right now. Because what I understood is that as a result of the Robinson Court's decision, Louisiana then enacts a map that it believes will remedy the violation that the Robinson Court has identified, and we're here on a challenge about that map. That I think we call as a Shaw problem. We're here deciding whether they can use race as a remedy, as people say they did in the construction of this map. So I guess I'm not even clear why the Robinson Court's initial identification of the problem is being questioned as a compelling interest, because there's an interest in not having an unequal electoral system, right?
That's correct. The Robinson decision is absolutely not before this court. There's no record in the Cali case to support that.
Thank you.
Thank you, Counsel.
Why did the state of Louisiana?
That from Justice Thomas. See, this goes back to what I was saying. Let me read what I put in here. 60 years ago, there was a great disparity between what the Constitution prescribed as appropriate and what was occurring under law and custom as it existed at the time. The fundamental atmosphere of one of conflict between a historical pattern of negating and depriving citizens of their rights on the sole basis of their perceived race, which of predominant concern at the time was that of Negro, Black, African American, Afro American, and guaranteeing the opposite circumstance of privilege for another, meaning the Caucasian or white race or whatever it might be. Now the deprived class, that is the Negro, is well insulated into the political and social process of the nation, and in fact dominates the whole of the political landscape in the largest urban areas. This is the type of political circumstance that is essentially typical for all ethnic, national, or local demographics. That's everybody else. The 60-year-old Rights Act presupposes that there will be a schism based exclusively on race that will be deterministic of any political agendas, objectives, or outcomes that might come before a legislative body. This schism required for remedial purposes that Negro voting blocks be permitted to ensure that fundamental access to political authority would be available to remedy historical oppression based on race. All traces of that have effectively been reduced to a certain background noise that is no more, no less than the generic xenophobia that impacts the population generally. In other words, there's no one alive now who has been a slave under the auspices of U.S. laws, nor anyone who has ever been able to evoke such offensive laws for personal nor collective benefit. In U.S. law, there is a strongly operated principle of reciprocity, i.e., sauce for the goose is gander as well. If you cannot permit whites to have a legislative advantage or legislated advantage, you cannot give a similar advantage to the Negro, except for remedial purposes. For example, when the reason for a law ceases to exist, so must the application of the law. And if Negroes have political opportunity that is essentially the same as for any other demographic, then there is no longer a justification for remedial compensation and corrective legislation. Going further, that means if you cannot discriminate against one group, say blacks or Negroes, you cannot discriminate against another, say Caucasians or white, unless for compensatory and remedial purposes resulting from the commission or complicity or offensive acts or policies by one group to the detriment of another. This being the essential essence of the Rights Act in question, the argument would be that there is no need for the remedial aspects of the act because the beneficiaries are no longer suffering any degree of debility to any extent greater or less than any other group based on any formal role of law or political utility. This has a factual contest based on the circumstance that you have the Obama pair, where every single office from the highest to the lowest has been held by someone purportedly from the formerly oppressed group. Since the First Amendment guarantees freedom of expression, aka freedom of speech, and categorically forbids any repression of thought, one cannot legislate taste and preference. When outcomes are the result of attitude, belief, and such other the things that cannot be legislated, then attempts to cure what cannot be cured by legislation with essentially futile legislation will not be countenanced under U.S. law. Under U.S. law, the proper redress for such phenomenology is ideas and circumstances and patterns of voting based on thought, is the use of the First Amendment to develop either an accommodating or remedial consensus. There is also another inherent presumption or operative assumption that is inappropriate. That is, in the interest of Caucasians and Negroes, are the interest of Negroes and Caucasians so diametrically in opposition that commingled groups of the two in a political manner must inherently be dysfunctional because of the irreconcilable differences in the nature of the two ethnic groups. Now, that's forbidden ground under U.S. policy. It embraces and presupposes that there are such fundamental and inherent differences in the racial demographics concerned that a dangerous inference of group superiority and inferiority might become formalized as policy. In fact, we see this very thing, the phrase white supremacy. It is an innate concept that presupposes an innate superiority of the Caucasian demographic over that of the Negro. That it has achieved a colloquial popularity is very dangerous, as it threatens to dictate an impermissible outcome of law and politics that essentially embraces the concept of inferiority and superiority based upon perceived race. Almost through. That the Negro or African American or black person seems to have accepted, embraced, and internalized this anathema in its psyche is disturbing. In other words, part of the mindset of this group is disturbing. Nevertheless, it is a driving engine behind the whole train of justification for the dysfunction that is generating the perception of victimhood that has begun to be so deeply permeating the culture. Perhaps this also adds a dimension to the practice of denoting certain ethnic factions by color, i.e., black, white, yellow, brown, or no more than superficial colorations overlaying a fundamentally uniform humanity, in the same sense that a given make and model automobile can be had in multiple colors without altering its specifications and performance potential. There are, of course, distinctions based on where the component parts of the car were made and or where they were assembled, or as been humorously put by somebody I work with, a very attractive female friend, who in answer to the inquiry of where are you from, said my parts were made in mainland China and assembled in New York by my parents. That is, someone of Chinese ancestry, but their Asian parents met in New York, and she was born there. He was being humorous, but that pretty much states the essence of the situation. This just acknowledges that there are very real matters of ethnicity that are subjective yet objectively valid, i.e., matters of national origin, religion, age, etc., that is set forth in Title VII of another Civil Rights Act as being impermissible considerations, say in employment. Now, these things are inescapable. You can't get around them. But again, the thing is, you cannot be discriminated against because of, but you cannot be given an advantage because of. Now, there are those that are nebulous constructs that flow from mental health issues such as transsexualism, though perhaps such delusional circumstances might be more appropriately categorized as organic handicaps. I mean, people are trying to throw that kind of subjectivity into the mix. where what's in a person's mind is determinative rather than what they look like, where they come from, what their sex is, what their age is, what their health status is. In any event, a primary concern, at least in the second century after the formal institution of slavery was violently ended by war and law, might be the continued perpetuation of the evils of that ancient institution by the remnant impact of what once were propounded as remedies. In other words, by continuing what they have from 60 years ago, now the argument would be it actually would be counterproductive and produce the events that the law attempted to prevent. Now, the analogy for this would be the consumption of a prescribed drug after its utility in addressing an illness is a pass to the point where someone becomes addicted and dysfunctional. In other words, into prescribed opiates. That's kind of what the gist of this is. The argument is this law a prescribed opiate that the public has gotten too addicted to or addicted to?
One last clip that I want to play, and it's of Kantanji. And she is actually comparing the voting rights. She's comparing Black Americans to disabled people. So just take a listen. And by the way, I like what you just read. That's very informative.
Thank you.
I guess I'm thinking of the fact that remedial action, absent discriminatory intent, is really not a new idea in the civil rights laws. And my kind of paradigmatic example of this is something like the ADA. Congress passed the Americans with Disabilities Act against the backdrop of a world that was generally not accessible to people with disabilities. And so it was discriminatory in effect because these folks were not able to access these buildings. And it didn't matter whether the person who built the building or the person who owned the building intended for them to be exclusionary. That's irrelevant. Congress said the facilities have to be made equally open to people with disabilities if readily possible. I guess I don't understand why that's not what's happening here. The idea in Section 2 is that we are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system, right? They're disabled. In fact, we use the word disable in Milligan. We say that's a way in which you see that these processes are not equally open.
What you're talking about is a personal perception of inferiority. It's deep in somebody's psyche like hers. She's got a white husband. She was an appellate judge in an area that has interest that very seldom touch on African Americans or Black folk. And she's on the U.S. Supreme Court as a token. Political correctness. I don't think she was the best selection that they could have come up with, African American or Black female. I would submit Roger E. Clifton, also on the second degree circuit, would have been a better choice, as would have been another lady that I know who's Black and female on that same second circuit. It was a political selection masquerading as a remedial thing, saying we need a Black female as a quota thing, not for excellence, but because the individual was a Black female. And what you wound up getting was a smokescreen for somebody on the far left with a certain kind of agenda that was revealed in its entirety by her response to the question, can you define a woman? And her answer, I cannot. So that's what you're getting, and that's what is also not stated, but that is a reality that is using an ethnic demographic as cover to get advantage for something else entirely.
Okay. That makes sense. I want to ask you a question, last question on this. Because this is ongoing, and I know we're going to be talking about this, more and more. Race-based identity politics. Do they kind of go hand in hand?
They do. One was remedial, race-based. That was originally remedial. Now it has gotten to be a custom, an addiction that the system suffers from, and it has become an ends in and of itself. We need somebody black and gay. We need somebody black and female. We need somebody this way. Interesting. What we have is an interesting morph to this addiction. You need a black female. Why? Just because. Well, what happened to masculine black males, black men? They seem to be also part of the outcrowd now. So is that not discriminatory based on race? And is the first one to get a black female just because she happens to be black and female, is that not giving a quota, an advantage to somebody because of their demographic? In other words, it would be like basketball, since we like that particular sport so much. Do you say that the championship team is not the champion because they didn't have enough white players on the team? So, in other words, you have to dilute the playing power of the team to get a number of whites on the team? Or we had a big, tall Chinese guy some years ago that got paid a lot of money. A lot of it went to the People's Republic of China, who played in the NBA. So do we need to say it's no longer based on ability, but we have to have certain quotas of each ethnic group playing in the NBA? You see, that's where you go with this. If it was back 1946 when the Lakers hired Don Barksdale as the first black man to ever play in the NBA, it's a whole lot different than 79 years later in 2025 saying we still need a quota for the number of black players that play in the NBA. That's ridiculous. It's just based on performance. They've come to dominate a sport in a majority white country, and that's just based on talent, acumen, and ability.
So my last question here, diluting black political power, because black people live amongst majority of black people. So when they say black districts, that is because 90 or 95% and sometimes 100% in that district is black, as opposed to there are districts that are 100% or 95% white, or it may be mixed with something else. So when with this district map, because this is the original argument, it's like, yeah, we have 31% of the population in Louisiana is black, 57% is white. So 88% of the Louisiana population is black and white, right? Which is a majority. And then the 20% is others. So, and a lot of times they kind of have their own little small communities, or they're spread it out. So if you are drawing up this new map and you are saying, oh, you can't include race, even though it just so happened majority of black people are living amongst each other, that makes up what, they're supposed to have two districts. So if you are using race in this situation, that is somewhat diluting what is quote unquote black political power, i.e. via the vote. It just so happened 31% of the population that are black live amongst each other. So they supposed to have two districts. They just so happen to be black, these two districts. So
But then you
I
go
think I'm
ahead.
looking at it.
Sorry.
I'm looking at it as they just so happen to be black. We're not going to get into why they live together because that's a whole nother thing. However, 95% of the black population in Louisiana districts live amongst each other. They're not spread it out. So they just so happen to be black but they are Democrat. So this particular block group here technically needs to have two districts, which is why they won the original federal court hearing. But now they're coming back. The other side is coming back saying, I guess the state of Louisiana is saying, you're doing it on race base. I don't think it's race based. I just think it just so happened to be majority black. Do you get what I'm saying?
I get exactly what you're saying, but the problem is, does it really make the question? Does it really make a difference? Let's take Memphis. We have the 9th congressional district here in Memphis, Tennessee. Harold Ford Sr. got elected to that position in 1974. He was black. He and subsequently his son held that position for 30 years. 30 years, all right? Until 2005. In 2005, another Democrat was elected to represent this 75% black district. He's white, he's gay, and he's Jewish. So you would expect that a predominantly black district, if race was the primary consideration, would be electing a third black congressman. But it is, for the last 20 years, 19 going on 20 years, returned a gay, white, Jewish congressman to D.C.
Right.
With 70 to 75% of the population black. He is promoting the demographics that he represents. But is that doing anything for the Memphis demographic of black folk who have a congressman whose primary showcase piece of legislation is a binding resolution that requires the congressional cafeteria to use paper straws? Now, what does that say about the realities of the circumstance? Is that really ethnic representation in Congress? Or is that just an agenda representation that in other places is hidden under the racial thing? Now, there's another thing too. They deny it now, but they proudly put it out 2 years ago, 3 years ago. The same person, Steve Cohen, the gay, white, Jewish congressman from the 9th congressional district, is a member of the Black Caucus. And he was also in charge of the Black Caucus's Commission on Reparations. So you had a gay, white, Jewish person in charge of reparations for black folk in their supposedly representative congressional body. Now, they don't claim that now. They want to get away from it, but I've seen the pictures.
But that just tells me that black people don't have a problem voting for someone who may not be black. However, I don't think that's the case here. So, because to me, it's not about race. It's not about you're voting, and even though the NAACP lawyer had her stats and saying white Democrats tend to vote for white candidates, right? But in this particular case, when we're talking about the black district in Louisiana, they are It's about numbers. And that's with any district. Like if it's a certain amount of numbers, then we should be allotted to have 2 districts because we make up 31%. So take race out of it and just look at the numbers.
Yeah.
So then,
And by the way, the whole thing is called gerrymandering. That comes from the late 19th century when somebody got the bright idea to advance political party agendas by drawing peculiar shaped districts to embrace the maximum number of people in that district from a given party to give it clout. News pundits said it looked like a salamander, so somebody created the term between salamander and something else, and they said gerrymandering, and that's where they get the term.
right.
So the districts aren't logical, they're just designed to give party advantage.
Right.
And
I think
that's essentially what you have.
Yeah, this is what I'm saying. No, I'm not a legal expert, but let me know if I'm on the right track here and if this makes sense. Take race out of it for sure. But if you look at the numbers, 31% of the population, that means you should be entitled to 2 districts and not just 1.
All right. The thing of it is, we still miss one point here. That presupposes that at this point in the 21st century, there is no commonality of interest between whites and blacks. Right here in the Memphis area, I'm beginning to see this. You have blacks and Hispanics and Asians who are saying, we appreciate families. We appreciate manhood. We don't like boys putting on makeup and going into girls' bathrooms or getting naked with our daughters in high school in the showers and in the locker rooms. We don't like that. We don't like certain other things. We don't like going down and seeing a gay pride parade where we've got our children passing through, going somewhere else, and they're looking at naked men with their dongs hung out in front of children in broad daylight. We don't like that. So we would say, screw race. Let's just deal with somebody who is going to, return decency to our community. Meanwhile, you've got the local Democrat Party, which is essentially 75 or 80% young black female, and the young Democrats, they're lesbians, and they tend to have an agenda that does not match up to what black, white, brown, red, and yellow as a majority would say we like. But they want to make the whole thing about race when we say, no, it's not about race. It's about sexual orientation and feminism. So that is not what the majority of people are into, no more than the majority of the people are into the Klan and incel, which is being anti-woman. So, it kind of sort of, it's not stated so much in front of an agency like the U.S. Supreme Court, but it ought to be. Is this a reality to continue to remedy an existing problem, or is this just a smokescreen to cover for the exploitation of this prior remedy, to use it to push an agenda that is not associated with the discriminated against class? In other words, it's no longer a black thing, it's a rainbow thing being covered under, you need to have black voters who will push this leftist agenda. Is this saying that black people can't get elected, or is this saying that black people who aren't like Jasmine Crockett can't get elected unless you have a majority black district where the exclusive issue is blackness rather than economics, education, crime, international considerations, things like that.
Okay. I want to share this one more thing and get your reaction from it. Two quick things here, just to mix it up a little bit. This is Nancy Pelosi in front of the Capitol yesterday, and she told a reporter to shut up when asked about the January 6th.
She's in the green, by the way, the lighter green.
Yes.
Congresswoman Pelosi, are you at all concerned that the new January 6th committee will find you liable for that day? Are you at all concerned about the new January 6th committee finding you liable for that day? Why did you refuse the National Guard on January 6th?
Shut up. I did not refuse the National Guard. The president didn't send it. Why are you coming here with Republican talking points as if you're a serious journalist?
The American people want to know. We still have questions. Thank you.
See, by the way, the problem with the First Amendment is the Democrats want to restrict those kind of questions and that kind of journalism. And that should be impermissible because it's a valid question and the documentation is there. I mean, they just deny it over and over. Trump wanted to send in the National Guard just like he's trying to do in certain places, and he has in others. Like in Memphis, he sent in the National Guard and the feds, and Memphis has been amazingly peaceful since they've been here, and it is no longer behaving like the homicide capital of the United States. So, I mean, it has its effect, but she's the one that didn't want it.
Right.
So that's a nice little dodge to act like you're offended by a reality.
So I want to play AOC talking about masculinity. And this was a town hall that her and Bernie Sanders did. Town hall shut down America, CNN.
And they are able to radicalize and target and exploit a generation of young boys, in particular, away from healthy masculinity and into an insecure masculinity that requires the domination of others who are poorer, browner, darker, or a different gender than them. And that is why they are resonating online, because they are appealing to the most basest and worst parts of human nature to divide us.
So let me just give a little background context. She was talking about Republicans are radicalizing and exploiting young boys and pushing them towards masculinity that requires the domination of others who are poor, brown, or darker, or different gender than them.
Well, you know what? That's why gangster hip hop rap is so popular around the world, because it looks like it's promoting masculinity. And young boys, by that I mean late teens, I call anybody under 35, they're children to me. But anyway, there is this concerted effort that the Democratic Party has been engaged in to emasculate the country. And what she is seemingly upset about is that there is a pushback saying, I'm not going for that. I'm a man. I'm not going for that. So I support the pushback. And no, I don't feel like it's being turned just to go after black males. That's crazy. I'd rather deal with a man wearing a Klan emblem than dealing with somebody wearing rainbow. Frankly, I know where the guy's staying. He's an enemy, but we have a commonality in how we approach life. So, yeah. But it is what it is, and you, as a man, have to recognize your enemies, your friends, your allies, and those that are neutral. That's like diplomacy on the world stage, just exactly like it on a mass scale.
Okay. Well, thank you, everybody, for tuning in to another episode.
There's one other thing, too. Are we going to do a separate thing on that other matter?
Yes, we are. So let me just close out. All right. Thank you, everybody, for tuning in to another episode of Injustice for All with Judge Joe Brown.